Well, my topic is best practices and new developments in high-stakes litigation and arbitration. And we've already really covered quite a bit about best practices. I think my two colleagues here have really underlined from an in-house perspective the best practice is keeping an eye open for settlement if we're actually already in proceedings where litigation or arbitration has started. And I'm not going to take that any further. I think what I can contribute has been touched upon as well, but nevertheless, the best practice has to be that there's a strategy in place. This strategy is something that in-house has been worked out. The different scenarios are understood, the repercussions on a business in one area that a dispute in another area could bring about, and as Abjid said, the implications on long-term business relationships have to be looked at very carefully. So a strategy is developed in-house and then communicated well to outside counsel so that they do not do something inadvertently. I'm not saying anybody does it on purpose, but inadvertently provides ammunition for a dispute that may be happening in a completely different area of the world. When I was in-house, we were predominantly working in Central Eastern Europe, Russia and the Ukraine. But we did have disputes that were brought against us in the United States. And it was very, very important that nothing was then done in any of the disputes, be it in Poland or in Hungary, that could then provide an opening for suddenly new disclosure in the United States that would be traumatic for the group. And that is really where I say I completely agree with Abjid about in a group, and a large industrial group covering loads and loads of different sectors, you need to have a dispute resolution policy, you need a reporting system internally, and then at the top, in the corporate centre decision-making level, a strategy is developed for any dispute that's come up through the pipeline in terms of what could be the implications for another dispute that's running somewhere else. And then this is appropriately communicated to outside counsel who realise that they must inform the corporate client and not go off on a frolic of their own. So I think that best practice, I know that there are outside counsel here, best practice can only be to have, once again, I underline, good communication with the client. Very from the outside counsel's point of view, really understand what your client is trying to achieve and where we're going. And if the client is simply trying to put pressure on the party in order to do a deal or do a deal somewhere else, that's something that you should pick up and be very sensitive to and understand that ultimately it is always a case of trying to make things work. And we've heard very much in a moving way that litigation is not something that we seek out when you're in-house. And I did not touch upon third-party funding, but I too am rather concerned about the implications that third-party funding brings. It may have positive benefits, but it could also equally have negative impact. And I think in a high-stakes arbitration, when you're talking about third-party funding, it's very important that my personal view is that this is disclosed at a very early stage. And I would encourage that as a practice if we're talking about best practices from lawyers' point of view. The other aspect, I'm keep it short because I do realise we started late and we're now way behind our schedule, is new developments. New developments in the field of dispute resolution, and in particular in my area of international arbitration that I feel is my area of expertise, is an interesting attempt to rebalance the relationships between the courts and arbitration, particularly here in the UK. And some of you may know about this debate where there's been an accusation that arbitration, international arbitration, takes away from the development of the law because it's confidential and it doesn't allow the courts to come up with new law. My point here has to be the law is there for the benefit of the client, not the client there to help development of the law. I feel that any arguments about the commercial party being obliged to go to court rather than choose and have the right of choice of its forum for a dispute is so important that it simply cannot be forced to bring proceedings under a particular set of rules. The other development, which relates to those of us who operate primarily within Europe, is the change of the investor-state balance of where disputes relating to investment claims are brought. And some of you may have been following this. It all has to do with the TTIP provisions that are being negotiated, and the view that the European Commission takes that there should be an equal playing field in terms of different nations within the European Union. I think that ultimately we must be aware that there is a balance to be struck between state control and the abilities of states to regulate how they want resources to be used and the legal environment, and that it must always be borne in mind that there is a separation of powers, and states do have a right to decide that they can expropriate, but it is ruled by the rule of law, which provides for compensation and appropriate recompense. And that sort of balance is something I think we struggle with in the current legal environment, where there is a swing towards supporting states. So there was a point where states were the baddies and the investors were always being caught out, and now there is a swing to say states are being limited, are being undermined in the way they want to manage their internal affairs, and investors are taking advantage of states. And it's really striking the balance. I think at the moment that is a new development. There's a debate out there, and the balance between the rule of law and separation of powers and how far states can regulate and exclude private individuals or private entities, corporate entities, from making a profit and find a fair and reasonable balance. I think that is a debate within the legal environment at the moment. Thank you. I'll leave it there.
Thank you very much to our three speakers. Before we have any questions, there's one small thing I need to do, which is to say thank you very much. Thank you.
Thank you.
Now, do we have any questions for our speakers? We have a gentleman there who's just raised his hand and another gentleman at the front.
A question probably for Abjit more than anyone else. Sorry. Hello. Thank you. How do you deal? I mean, obviously, I'm an external lawyer. How do you deal with problems where you might have an internal conflict within your organisation, and I don't know that, and I've got a litigation strategy to follow? How would you deal with that?
I think I've already replied in the sense that I want my external counsel, big, small, medium, to act as an extended arm of the legal department. Now, if I expect that, it's my duty to give you the background, the chemistry, everything. I'll give you one small example. In London, we are developing one huge real estate project. It's a $1.4 billion project. We are setting up a 7-star luxury hotel in Trafalgar Square. We have bought over the old War Office, which is a 100-year-old building with 500,000 square feet, where the war was fought from that building. Be that as it may, I have engaged 6 separate law firms. Some of them are biggest names in the world, because we have got a very strong Spanish partner also. Okay. Now, my chairman, he was not very happy with the head of the real estate, who is a very senior partner in one of the global law firms. The message came to me, and the chairman was so upset. Even he was telling me, can you replace the law firm? I said, no, I'm not going to replace it. Let me put it in a different way. Bottom line of the story is that I worked through the partner, I worked through the law firm, because I know many other partners in that law firm, told them that this is internally what we want. This is the chemistry that you should have. So therefore, you please correct yourself, and we would like to continue with you. My bottom line is that I work very closely with the law firm. I have got the greatest advantage because of my networking. I think there are friends everywhere. In such an event, my relationship with most of the external law firms is that of more or less at a personal level than anything else. I treat them as a part of us. I will tell them the internal confusion, internal politics, internal chemistry, so that they really understand that and they are at sync with what the organization wants. That's a very difficult task to do, challenging one, but I have seen that if you are very objective in your mind, the intention is to work in harmony, at peace, not to act as some kind of cross purposes against each other, then definitely it will work.
Thank you very much. And there was another question from a gentleman here.
So my question was again related to that external counsel. So most of the you have already answered. So I was just concerned, if there is any specific policy for selecting the outside counsel, because we have been discussing that all the way. But if we have a kind of cheat sheet, 10-pointer or something, because they really need to know what exactly is the way. How do you choose the outside counsels? One is like there is already, you look them as an extended team. You look for all the, So just the pointers, do we have any policy, the strategy for selecting the outside counsels?
The greatest advantage that I have in my organization, there is no panel. So therefore I am free. The first and foremost thing, what I see, what is the matter? Small, big, in such an event, then who will be the external law firm who can help us in this matter? Say, for example, giving the same example of the real estate. First, when it came to me, I realized that there are a couple of law firms who are really good. So therefore, that is the first thing, what kind of competency level the law firm has got. That is the most important thing. The second thing I always look for is, do we know anybody there? That's very important, because at the end of the day, the chemistry should match. The project will go on for 5 to 6 years. So therefore, unless and until there is a complete sync, complete chemistry between myself and my law firms at different levels, we won't be able to work. So that is the second criteria. Do we know anybody? Third criteria is obviously the fees. And there we innovate, we apply all kind of methodology. You will be surprised to know, for such a large real estate project of $1.4 billion, I have negotiated, which is a fixed fee on milestone basis running over a period of 6 years. Even my chairman said, are you sure? We can call them whenever you want. I said, you call them. There are 11 partners who are involved from that particular law firm. So therefore, that is another criteria. These are the 3 criteria that we see all the time.
I'm so pleased to hear that there's a general counsel who's saying he doesn't use panels. I must say, from my point of view, panels are a disaster, and the in-house lawyers, that when you select them and when you recruit them, what you're doing is selecting skilled buyers of legal services who know the market. So then imposing a panel structure on them is, I always find, a disaster.
True.
Thank you very much. There was a gentleman here who raised his hand over in the corner. Sorry, just behind you with the microphone, and then we'll come to you. But I want to make this the last 2 questions, because we are in our coffee break already. And okay, well, let's have these 2 then.
All right, thank you. Well, my concern as an external counsel is managing information with the in-house counsel. Most times you find a situation where you have a fragmented approach to a dispute resolution mechanism, particularly in respect of a dispute that has a multi-jurisdictional approach. Most times you have law firms all across the globe working on the same dispute resolution, and it becomes sometimes most difficult for the in-house counsel to relate some of the information across the various jurisdictions to the respective external counsel. My question is, how do you as in-house counsel ensure an effective concerted effort from the various counsels, because you find it hard to deal with when a client is giving you a fragmented information. Today it tells you to do this, tomorrow it tells you to do this, and you go on and on for years not knowing the objective of the corporation in most cases. There are cases like that. How does an external counsel deal with that?
I think it's an excellent question. I'll put it in that way. When we engage counsels, that can be basically for 2 purposes. One is if there is a dispute, then you have to handle it. The other one could be for business purpose. We have got joint ventures all over the world. So therefore, for making business, we need the help of the external counsels. The way I look at it, I always categorize this, and when I say I, it's really the policy of the group also. We categorize the legal activities that are being generated, that are being done by the legal department at the global headquarters here on ABC analysis basis. Which are the issues which should merit my attention? That can be a business opportunity, new businesses, joint ventures, old businesses. That is a business related matters where the external counsels are all involved. Then the other issue is litigation, arbitration, dispute, even I am including the settlement there also. I have got a list of ABC. Based on that, it is very important what you just now said. It is important, and it is a point that you also raised, that if I don't pass on the information, and that information may not be the basic information of some agreements or something or some documents like that, even the minutest of details, if I don't pass on, I agree that it is not possible for the counsels to really to produce the best results. So what I do, where there are ABC analysis, I will talk to them, my departments will talk to them. I have got a number of young lawyers working. I said, just, come out of your seat, go to the law firms if they are in different parts of the world, go there, talk to them. Otherwise, pick up the telephone, talk to them. Don't rely only on the emails. Talk and talk. That is how you can really make the other party understood that there is a proper sync between the external counsel and the in-house counsel. That is one part that we do. Second thing, what we do, whenever there are internal meetings where we feel the external counsels also should be invited, we always invite the external counsel. I was talking about this particular $1.4 billion project. We are going to have a big workshop which will be conducted by Deloitte, and I have invited the law firms, all the 6 law firms, that you come and attend. It may be a tax kind of workshop. It may be a strategy related workshop. But if you attend, you can see my body language. You can see my chairman's body language. You can see the other director's body language. And from there, I'm sure you will have a lot of takeaway, and it will be easy for me to deal with you. So I can't give you one line answer, but it is important, if it is your policy, that I must keep the external counsel informed in every single way, then only it will work. I don't consider external counsel as I am the head examiner and they are the students, let me examine how they are performing. No, that is not the intention. Intention is that we should work together. And if you can't work together like husband and wife, if I don't share the information, then obviously the marriage will fail.
Thank you very much. Our last question.
Sorry, may I just,
yes, of
may I
course.
just quickly add? You see, I have gone back into private practice, and I'm very conscious that it's the relationship that is so important. You have to build trust, and then the information flow will be in both directions. And that is really what I can only urge on outside counsel. If you feel you're not properly informed, you don't really know why, ask and build a relationship with, and clearly we've got Abjit here, who is the example of how to do it.
Yeah.
And it must be a real pleasure to be able to work with Abjit. But I've come across internal counsel who are a little bit nervous because they know that certain individuals within the corporation may have made mistakes. And you have to be very sensitive to that sort of situation, so that you really need to just build trust and then get that information flow so that you know the strategy that is being developed in-house.
Thank you. So our last question.
Well, in actual fact, it's no longer a question, because it was exactly the same question here.
Oh, I'm sorry.
Based on the submission that the merit of an external lawyer, and I'm an external lawyer, the merit of an external lawyer is indeed to be a prolongation of the interests developed by the corporation in the strategy and in the way they see the conflict develop and what should be achieved. But the real value of the external solicitor, in my opinion, is to challenge the decisions or the perceptions of the organisation itself, because it's the outside view which will give the corporation a chance to evaluate and assess in a proper way and based on full disclosure, of course, of any information. The opportunity to assess the risk involved. So if it's not an independent advice which is given, there is no reason whatsoever to use an external solicitor, is there?
Thank you. A good thought to end on. Well, thank you very much, everybody. Thank you to our panellists.